You guys are going to love this one.
Okay, folks. I've trimmed 2 hours of committee down to 31 minutes. It's mostly going to be the Ryan show. So for all of you who tuned in just to see David Moscrop,
sorry,
my sincere apologies. Not really. My sincere apologies. And I do want to say, to David's credit, he was very professional. He was very cordial before and after. And we even discussed the revelation that I gave him a little bit more after. So I have to say nothing but positive things about the interaction with David Moscrop, to his credit, even though he in his personal politics he leans very left, but it's important to be able to come to venues like this even when you're on different sides of the political spectrum, and realize that you can come to some common ground on some issues. So so I just want to say that about Dr. Moscrop. So I'm not going to be dumping on him or anything like that, because he came in good faith, and he showed that he had an open mind today. So that's what I want to say about that. Okay, folks, let's take a look. Thank you for the invitation to appear. My name is Ryan Davies, and I am president and co-host of Northern Perspective, an independent Canadian media platform focused on parliamentary transparency and civic education. I'm a 20-year IT professional and executive where I have spent my career leading teams, improving systems, processes, and organizations across broadcasting, healthcare, data management, and government sectors. We have already made multiple recommendations within our parliamentary petition on how to address the longest ballot problem, such as mandating 100 unique signatures, candidates signing an affidavit of genuine intent to run, and fining candidates up to $2,000 if they fail to live up to the genuine intent to run. We first reported on the long ballot during the Toronto-St. Paul's by-election, but began a deeper investigation after the group publicly announced its plan to run more than 200 candidates in the Battle River Crowfoot by-election. What followed raised serious concerns about the integrity of the electoral process. In July, following our expose on the group's origins, we interviewed a verified LBC whistleblower and obtained internal communications, including text messages, emails, and organizer videos sent to LBC candidates. These materials, along with the group's own public posts, reveal 4 key findings. 1. The internal communications show a centralized direction, coordinated timelines, standardized messaging, and top-down instructions from organizers to participants, functioning in practice like a political party apparatus rather than a decentralized protest. I believe this is a direct violation of the Elections Canada Act, as they are operating as a registered political party despite not being registered. 2. Our evidence shows that organizers state they, quote, already have the signatures for participants who had not yet registered or even agreed to run. The communications we received from the whistleblower acknowledges that signatures were collected before organizers knew who the candidates would be. This is a clear violation of Section 67 of the Canada Elections Act and may amount to forgery under Section 366 of the Criminal Code. In his testimony on October 2nd, the Chief Electoral Officer confirmed that Elections Canada has seen the longest ballot committee submit blank forms in past elections and confirmed that the candidate name must be present. 3. Key internal messages state that there were no authorized delegates acting for specific candidates while signatures were being collected. Electors were asked to sign without a properly authorized representative of that candidate, as emails show organizers asking candidates to ensure they designate their delegate after signatures had been collected. This violates Section 67(4)A of the Elections Canada Act and constitutes impersonation under Section 480.1e. This was further corroborated by reports from volunteers for the Libertarian candidate, Michael Harris, during the Battle River Crowfoot by-election, who heard from electors that individuals had approached them falsely claiming to be collecting signatures on behalf of his party. 4. Separate from signatures, our investigation uncovered a substantial and sustained overlap between LBC and the Marxist-Leninist Party of Canada. LBC messaging, announcements, and narrative pieces regularly appeared on the MLPC's official website and social channels, with posts encouraging voters to support candidates of the longest ballot project. We could not find similar statements on any other social media platform, including the longest ballot committees. We invited the LBC to appear on air to discuss their conduct, but they refused the opportunity. One candidate initially agreed to an interview, but then withdrew after being told by organizers they were not allowed because the narrative could not be controlled. Shortly after our whistleblower episode aired, we then received a legal demand to remove all coverage of the longest ballot committee within 48 hours. We declined. We compiled our evidence package and emailed Elections Canada on July 25th, 2025 at 12:06 p.m. Eastern. To date, we have received no response. The longest ballot committee is not a protest. It is a coordinated campaign of mischief designed to make a mockery of our democratic process by violating the Charter 3 rights of Canadians across this country. Nothing more.
Thank you so much, Mr. Davies. We'll now turn to Mr. Cooper for 6 minutes, please.
Thank you, Mr. Chair. Thank you to the witnesses. Mr. Davies, you testified that you've interviewed and you've been in communication with a whistleblower who has been associated with the longest ballot committee. That whistleblower provided you with communications from the committee, including text messages, emails, as well as photographic evidence, correct?
That's correct.
Okay. Now, pursuant to the Canada Elections Act, in order to get onto the ballot, a candidate must receive the signatures of at least 100 electors endorsing their candidacy. Some of the text messages and email evidence from the committee indicates or evidences that the committee was collecting signatures from electors before they had candidates to collect signatures on behalf of in violation of the Canada Elections Act. Is that fair?
That's fair. And even some of the text messages that we have from the whistleblower confirm that they hadn't even started the process and were asking for help in order to navigate that process while the signatures were already in hand, as evidenced by the text messages.
Okay, so I'm going to go through some of the relevant text messages and emails, copies of which you provided to me. I have an email dated May 30th, 2024, a mass email, or it appears to be a mass email, sent out from the longest ballot committee. This was during the Toronto St. Paul's by-election. It reads, please excuse me, just throwing out the invite one last time. And then it goes on to say, we've collected the 100 nomination signatures you will need, and we'd love to have you, but certainly understand there are many, many, many good reasons not to participate in our crazy project. Just 3 more days till the deadline for candidate nominations arrives. Signed, Kieran Shukavich. So how is it that electors could have signed nomination forms endorsing candidates before the candidates themselves knew that they were candidates?
Well, and that's the whole question that we're asking, and that is why we try to raise awareness on this and email Elections Canada to ask about this, because if a candidate has not registered as a candidate and therefore has not authorized somebody as their delegate, how can you have that authorized delegate that hasn't been authorized to actually collect the signatures in the first place?
Well, precisely. And then I have another...
Okay, so I can actually see the reactions. I saw Blaine Calkins, he was just laughing. He's like, this is stupid. So that's, that, I wanted that answer to land, and I'm really glad that it did, because it's a tricky one to get out. But it's so important, right? It just illustrates the problem with this. You can't have someone, okay, so look, just the basics of it. What the Elections Canada Act says is only the candidate or their authorized delegate can collect a signature for their nomination. That's it. People can go with the delegate and they can be the witness, but they can't be the ones to actually collect the signatures. So the problem is that the longest ballot goes out, get these signatures, and then comes to people that are prospective candidates and say, here, we have your signatures. Go fill out the paperwork. Oh, and by the way, don't forget to mark him as your delegate.
Right, but that's the evidence we found. But the testimony given by Thomas on Tuesday says that's incorrect, that they're just encouraging people to, go to the returning office and finish their paperwork?
Well, no, Thomas didn't actually disprove that. All he said was, we know the people that are interested. Well, sure, if you know the people that are interested, that doesn't mean they've authorized you as a delegate yet.
Right.
That's very different.
Yeah.
Like,
which is why your testimony was focused on that particular issue.
Right. So it calls into question all of that. And the smoking gun is, we have an email from the longest ballot to the whistleblower saying, we have the signatures, go fill out your forms, and please make sure that you assign Thomas as your delegate. Which means the whistleblower's candidacy for Toronto St. Paul's was completely invalid. That's what that means. Like, there's no question on that. Case closed.
Then I have another text message exchange between the whistleblower and Kieran Shukavich, dated August 16th, 2024, and during the LaSalle-Imard-Verdun by-election, in which the whistleblower writes, how many people so far going to break the record, as in going to break the record of candidates, to which Shukavich replies, it's 53 right now, probably 60 tomorrow. We collected signatures for 109, so it's possible we'll break 100, but it depends on who can get it all done in the next week. Fingers crossed. And then 2 days later, there was a video posted on the Longest Ballot Committee's YouTube channel of Thomas Shukavich, with the title below, the title of the video being message from the official agent. Now, I've watched the video, and Thomas Shukavich states as follows: if we're going to break the record of the Longest Ballot Committee, we need everyone to sign up as soon as possible. We've already collected 100 nomination signatures for you. Now, just to be clear, that YouTube video has been removed by the Longest Ballot Committee, correct?
After expose, they removed that, and a lot of the other longest ballot organizers disappeared from social media.
Okay, very interesting. How convenient. And then there is a text message from, again, Kieran Shukavich, dated March 31st, 2025, in the context of the Longest Ballot Committee recruiting candidates in the Carleton riding, in which he states to the whistleblower, I emailed you the nomination signatures and official agent form a few days ago. Now, you've talked to the whistleblower about his involvement in the Longest Ballot Committee. According to the whistleblower, he had not indicated any interest in running for the Longest Ballot Committee in Carleton, correct?
That's correct.
He was not involved in the Longest Ballot Committee at that point.
That's correct, and evidence even shows that there's repeated attempts by Kieran to engage him over the course of several days and even the course of a week, trying to get him to say that, yes, I'm going to run, and there was no response by the whistleblower.
And yet the Longest Ballot Committee here already had collected his signatures. How's that possible?
Well, and that's the whole point, and
Right.
It wasn't. And in fact, in Thomas Shukavich's testimony on Tuesday, he was even trying to say, well, we already know who's interested, and then that's how we know how to collect the signatures. But if they haven't registered as the candidate, and there's even another email that we have that specifically is from the Longest Ballot Committee to the whistleblower asking him to, don't forget to assign Thomas as your delegate as soon as possible, but in the same email they say they already have the signatures. So one cannot happen without the other if you're playing by the rules.
Okay, well, Mr. Chair, this evidence is very disturbing. It raises serious questions about whether the Longest Ballot Committee collected invalid signatures, which in turn raises the question, how many candidates connected with the Longest Ballot Committee have appeared on the ballot who should not have because they didn't have the requisite valid 100 signatures as required by the Canada Elections Act, and it raises further questions about whether the Longest Ballot Committee broke the law.
Very brief response. We're at.
I would just say it's, when you look at the scale of how many candidates that the Longest Ballot has actually engaged with since they started back in 2019, and you multiply this procedure, if they've been following it every single time for every single candidate, you have hundreds of violations of the Elections Canada Act, and potentially that compounds because it could be impersonation, it could be obstruction, and depending on how the criminal justice code interprets it, it could be amounting to forgery as well.
Okay, thank you, Mr. Davies. You can elaborate with further questions.
Hundreds and hundreds of violations. Can you imagine?
Yeah. Well, if you have 200 people, 200 candidates on the ballot in Battle River Crowfoot that are from the longest ballot committee, and if things were done improperly for each candidate, that's at least 200 violations.
And it doesn't even matter. Like, it just has to happen for one. Like, let's say 199 registered and authorized them as a delegate, but that's not likely, because what the longest ballot, they advertised this, and this is what our whistleblower said. They said, all you have to do is give us your name, we'll take care of the rest. So, and you look at the communication from the longest ballot to the whistleblower in each of these by-elections that they've tried to get him to run, and it's always signatures first, paperwork second. Well, paperwork has to be done first to make you the authorized delegate in order to allow you to go and get the signatures. So you can't register as a candidate afterwards and then authorize this person as your delegate and then retroactively make it okay.
Merci
Ms.
beaucoup.
Normandin, 6 minutes. Thank you. I just want to make sure that you are hearing the interpretation. Since the beginning of the study, the main question we've been putting to ourselves is how to find a balance between the potential need to reform the Elections Act to prevent initiatives like that of the Long Ballot Committee happen again, or avoid doing that, because there would also be repercussions if legislation were more restrictive. So we need to find the right balance. So my question is to both of you. Do you believe that with all that we've discovered about the longest ballot committee and the violations of the Elections Act that they involved, is there any possibility that the movement dies out by itself because fewer people will be tempted to take part in a move like this if they knew they would be violating the Elections Act?
I mentioned forbearance earlier, and I'll tell you, I was thinking about this yesterday walking around. Like, I'm going to think about this as a democratic theorist. I'm going to think about this as a journalist. I'm going to think about this as a citizen of this country. I'm going to think about this as someone who actually supports electoral reform. What's the best outcome here? And the best outcome is they stop. They take the message. They exercise some forbearance. And they say, you know what? This isn't working. In fact, it's doing harm to our elections, but also to their stated goals. Let's try something else. Let's move on. And then perhaps the Parliament could look at small legislative changes to make it slightly less likely this happens in the future. But honest to God, I think the best answer is they stop. And I know they'll be seeing this, and I certainly hope they take that message to heart, because it's not doing us any good.
And what I would say is we've done a lot of monitoring of the long ballot social media, and they've been monitoring these committee meetings. They were monitoring the committee meetings last fall, and they have heard all these suggestions, and on their own social media, they're posting, don't worry, no matter what they do, we're going to continue. So they seem intent on this, and I think that's evidence back from the original court decision in Alberta of 2017, where the lead organizer, Kieran, tried to have all of the restrictions to register as a candidate to vote wiped away. And luckily, the Judge Inglis ended up only striking down the $1,000 bond.
Une autre question. Avec la loi électorale.
One further question. With the Elections Act as it is now, do you think there's a way, rather than amending it, to apply it more effectively to prevent this from happening again or continuing?
Signature checking. I mean, I did listen to the testimony previously and hear that some candidates, the returning officer rejected something. So there was a check and balance there at some point. But here's the thing. If there are problems with signatures, that needs to be caught before a candidate is on the ballot. If it's caught after the fact, then we're talking about consequences for that. But the damage, to some extent, to the public good is already done. So if people are sneaking onto the ballot that ought not to be there, that's a problem. And now we don't need to talk about checking these things a priori. Incidentally, if we can't control signatures now, if we're going to introduce further restrictions on signatures or requirements, we need to be sure we're ready to actually check them. We can't say, well, we'll let Elections Canada figure it out later. And this comes at a time when the country is looking at reducing budgets. So there's also a budgetary concern, as if we're going to spend money, are people going to be ready to spend this money to do it? So I would say, before we start looking at making things tougher, make sure you can actually enforce the regulations you have currently on the books.
And I would say, I agree, money is going to be the issue here. The issue with the Elections Canada Act as it is right now is I look at this from a process architecture perspective, where this is just a big process on how to run an election. However, I don't see any controls in place for this process. So you can say that a candidate or person who must be who is authorized to act on a candidate's behalf, that is a requirement. I don't see any way to enforce that. Where's the control for that? And there's many other examples in the Elections Canada Act where that's the case. And the Chief Electoral Officer even admitted that they don't have the resources to even implement any controls to check the act as is.
Yeah, this was interesting. So basically, David and I kind of agreed. We just said it in different ways. And when it came to, are they going to stop? Are they not? It was interesting. I think David said that they should stop, and what I had said,
they probably will stop, is kind of what he was saying.
I think that was the implication.
Yeah.
And then I came in following that right after and said, no, they're not. I've read their posts. They're following this, and they're saying they're not going to stop. So,
but in terms of the process thing, if there's no controls, you had said, what are you going to do? It's kind of like if there's a law, okay, you can't speed, but we have no way of telling whether or not you're speeding.
Well, not even just that. We have no way to prevent you from speeding. And if you do, what then?
Well, and if you
right?
do, we can't tell that you're speeding.
So this is the challenge, right?
Thank you very much, Chair. Mr. Davies, in your opening testimony, you appeared to be, well, you were very clear in what you surmised to be happening here based on the information that you have. Could you elaborate a little bit more on why you think the Longest Ballot Committee is actually operating as a political party rather than as a protest group?
Well, you just have to look at your own political parties, and it doesn't matter which one you're a part of, Liberal, Bloc, NDP, Green, PPC, what have you. If someone wants to know more about your party, where do they go? They go to your centralized party website where you have all of your media. And the Longest Ballot, they were centralized on X, and now they're centralized on Blue Sky. Most of their media isn't there. They have random social media posts they put up there, but all of their formalized statements, political statements, and formal responses to even committee meetings, statements by the Chief Electoral Officer, they're all posted on the Marxist-Leninist Party website. So there's that. So they formalize all of that into one specific website. But where it really comes into play is they operate as if they're a political apparatus. They're talking to their candidates as if they're running across the country, but they're not. They're running in one riding. They give them all one direction. They're running under a single platform. They are...
Just to be clear, a political entity is only allowed to have one candidate on the ballot in each constituency. Is that correct?
That's correct.
So you believe that because they're either committing an offense by running more than one candidate, or they're failing to register as a party. Is that correct?
Correct. The main crux of it is a registered party is only allowed to run one candidate per riding. So they get around this by not being "quote unquote" registered. But
do you think a legitimate candidate gets 0, 1, or 2 votes in an election?
I think a legitimate candidate would be embarrassed to get that amount.
Interestingly,
I'm just sitting here smiling at Cooper smirking.
I also saw Calkin's eyes at the end. He was like, "That's
and
crazy."
You know what? I was sitting at home and I was like, "Yes, that is an excellent answer."
Which one? The political party one?
No, the one that when Calkins asked if they get 0, 1, or 2 votes, and you said a legitimate candidate would be embarrassed to get that few votes.
Well, it's true.
It is true, and that's why it was great.
So, and it was just funny seeing his eyes go like really wide at the end, and yeah, Cooper sitting there like. I like how this is going. So, I was getting more and more fired up at the end. So
Yeah, you were. I noticed that too.
I've been personally quite frustrated since 2017 with the decision by a court in Alberta, which ironically, the witness that was here on behalf of the longest ballot committee is suggesting that people outside of Parliament should be making rules. So here we've had a rule made by a judge in Alberta in 2017, somebody who's not a politician and has never likely run for it, appears to have no political experience whatsoever, has now made a decision to remove the $1,000 bond. I've often thought it was a mistake by the government at the time to not appeal that decision. Can you tell me more? The individual, the case was Kieran Shishkevich versus Canada in that particular case. Is there any relation between that Mr. Shishkevich and the one that testified here 2 days ago?
Sure, he's the brother of Thomas Shishkevich, and the biggest thing that jumped out at me in this decision is actually paragraph 23, where it says the applicant submits that while the deposit requirement is allegedly an attempt to deter frivolous candidates, it may well deter non-frivolous candidates who are not affluent. So,
does the longest ballot committee, in your opinion, have anything but frivolous candidates?
No.
Do you think that, so obviously, from my perspective, this appears to be a well-orchestrated campaign that started well before the and they knew that they would have to get that $1,000 bond removed and actually were prepared to go to court. What does that suggest to you about political motivations and the actions of an actual political party?
I burst out laughing after you were like, no, and then Cooper just smiled.
well, because I said it was like the stupidest thing I've ever heard, because it is, right? And
Not
it's
the question, but the fact that
right.
That's what the longest ballot committee is doing.
And it's funny because Tanya was telling me over the phone, she was saying, I loved seeing Cooper's reaction. And I again, I'm not paying attention to Cooper, and I'm seeing him now, and he's just like doing his little adjustment and smiling, and it's funny.
That was good.
It is funny.
Well, given the fact that they're trying to get all of the requirements removed, this seems to be a well thought out, orchestrated attempt to engage in this behavior in the first place. Because after he won this court challenge, did he run in the election? Not as a legitimate candidate. All of a sudden he teams up with the Rhinoceros Party and they start running these long ballots. And the biggest thing about this court challenge is this was him saying this is violating his Charter 3 rights. But now they're going on to violate the Charter 3 rights of people with disabilities and seniors across this country. And for people to say that this is a small issue, it is not. This is an issue that our forefathers fought for. Yeah. And we need to take that seriously.
Couldn't agree with you more. With all of the information that you have from the whistleblower, plus everything that we know in the public domain, is there anything that leads you to believe that the longest ballot committee is actually just a protest, or are they operating with clear and decisive intent?
I think the fact that they couldn't even answer the chair's question about, okay, fine, let's accept that this is a protest. What's your solution? And they don't even have a thought out solution. And then they've been doing this for 6 years. They haven't thought about that at all. This shows that they're not serious about an actual resolution, and this is just malicious intent.
Yeah, the back and forth with you and Mr. Calkins was really good.
Well, I've seen a couple of people say that they've watched the section a few times because I think this was probably one of the more important sections in the testimony, because this kind of ties everything together, and Calkins seemed to be trying to say, okay, so what's the big picture here? And that's what people need to see is what that big picture here. We can argue on the individual violations and these things, but the real question is, what are they trying to do? And that was my opinion, right? So and the great thing about speaking in committee is I can say whatever I want and be protected by parliamentary privilege and can't be held liable for it. I have to be careful outside of committee, but I can just say, well, look what I said in committee. That's about all I can say.
Could we talk about the balance that needs to be struck between the risk of limiting non-frivolous candidates and the negative impact of constraints? It might be acceptable in some cases to democracy to have some frivolous candidates.
I think the issue here is how do we uphold everyone's Charter 3 rights? How do we protect the the people that are most disadvantaged in terms of allowing them their democratic right to vote. That's one of the main concerns here. But we, to the point, we don't go too far in the other direction in overreacting. But I think we need to enforce the act. That seems to be one of the biggest problems we have in this country overall, is enforcing the laws that we do have. And where having an honest review of the Elections Act, there is a determination that there are missing controls in order to do that, we need to come up with new controls and punishment for people who try to weaponize democracy against itself.
Thank you very much, Mr. Davies and Madame Normandin. We will move on to Mr. Jackson for 6 minutes, please.
Thank you, Chair, and thank you, gentlemen, for being here today. Just like to start with Mr. Davies, a couple of questions. You mentioned earlier in your testimony that you or your organization filed a complaint with Elections Canada regarding the longest ballot committee's actions. Can you just make it very clear on the record who specifically you submitted that claim or that complaint to?
So we initially contacted Elections Canada by phone to ask them how to report this, and then they provided, I believe it was the email address, info@electionscanada.ca. That's the mailbox we were advised to send it to.
And to date, you have received no response to that. Is that correct?
Correct.
Okay. Would you be willing to table all the evidence and correspondence you have between yourself and your organization and the whistleblower, so that we have that evidence, which I assume was part of the complaint that you filed to Elections Canada?
Certainly, and yes, it was.
Okay. Thank you very much. Just now to Mr. or Dr. Moskrip, I want to thank you for your testimony today.
Before we get to the next question, Calkin's reactions to this is just, he's dumbfounded, and he's dumbfounded that this was reported to Elections Canada and nothing happened.
Well, and quite frankly, so are we.
Yeah, we were just waiting, and we thought, oh, they'll get to it. They'll get to it. They're not getting to it.
Well, and we spoke to our MP, right?
And afterwards, Calkins had asked me a bit more about it, and I said, and I'm glad our viewers had actually emailed us, because some of the viewers had said that they had reported a complaint to Elections Canada regarding the Battle River Crowfoot by-election, and they got a response, and I told them that, and I said, well, our viewers got a response, we never did. They said, well, what response did the viewers get? And I said, I don't know, it wasn't serious though. So
it was just like brushing people off, which,
yeah.
I mean, this is serious stuff. This is somebody monkeying with our democracy.
Do you have any further perspective on Mr. Davies' commentary about the longest ballot committee, rather than a protest movement, operating as either a political party or a third party, which has been suggested as well in previous conversations, that this is a centrally organized group of a very small number of individuals who are giving central direction to sometimes not even full candidates yet, we've heard in testimony, people who are prospective candidates, and whether they should be governed in some way by either the rules that govern third parties in our elections or the rules that govern political parties in our elections?
Very brief answer, Dr.
I hadn't thought about it until Mr. Davies brought it up, but I found his argument cogent. And again, I'll go back to this. We have effectively an exploitation of loopholes in the law right now that are in violation of the spirit of the law. And I think Mr. Davies made quite a cogent argument.
A cogent argument.
You can change the mind of a liberal. That was one of the things that I took away from today the most, actually, is that the witness that the Liberals called, and he wasn't brought in to be against me by any means.
No, you were both just brought in to provide purview on the longest ballot issue.
Right.
Yeah.
But the fact that he was willing to listen and actually listen to my answers as I was listening to his answers, and say that, I never even occurred to me, that's a cogent argument. Cogent meaning logical and valid.
Thank you. I had to look it up today.
For those that don't know,
me.
That's what that means. And again, liberal PhD sitting right next to me saying, dumb YouTuber. And I know I'm not a dumb YouTuber, but that
No.
that's the perception, right? By the liberals. And he gave me a lot of credibility by saying that to the liberals that were sitting there. So I applaud David for that, and for having an open mind and really listening. And I think we need to be able to do this more often. We need to be able to find that common ground more often, because this is how we move forward, you know. And this is why it was so important for me to, because if I came in here very partisan and riled up and trying to antagonize the liberals, that wouldn't have happened.
Right, and you need both sides to bring, you know, their view to the middle, and then you can create something good out of it. Because just for example, if David didn't have your input, then, you know, maybe the conclusion of the committee wouldn't be as whole. Like if it was just his opinion, he hadn't previously thought about what you had said. So because, you know, you're coming from a different vantage point and that you're able to add that in, now it creates something better for committee as a whole.